An accident in the workplace is where you could be going about your normal job and you sustain injury through no fault of your own.
Workplace accidents can take a really wide range of forms. It can be a problem with machinery, it could be a problem that has been caused by another employee, it could just be an absolutely whole wide range of things that we're consulted about that might happen.
It's worrying for some clients to come to us with accidents at work because obviously what they have to consider is their employees will become aware that they're making a case against them.
In the vast majority of cases, that company will have a policy of insurance in place, and the reason for the insurance being in place is in situations like this. When the letter of claim's sent to them, they will then send it to the insurer.
We deal with the insurance companies of their employers, so we won't be dealing direct with their managers or their supervisors. We'll be dealing with their insurance companies, and if they do have any problems at work as a result of putting forward a case, they can always come to us and we will advise them.
In the vast majority of cases, we would be more than happy to represent the client on a conditional fee agreement. They're more widely known as no-win, no-fee agreements, which are pretty much as they say on the tin, in that if the claim is unsuccessful, you don't pay us anything.
So if you're injured in the workplace, we would invite you to come in and see us, or we would visit you at home. We would take some initial details from you, which will help us to prepare a statement to understand what's gone on. If there are any witnesses, we'll speak to the witnesses for you, and then we'll gather documentation to assist us in establishing your claim.
If you suffered injuries through no fault of your own, and we approach the insurers and they admit liability early on, then we would then get a medical report, we would assess damages, and then we would make offers, so it can be quite a straightforward process.
If you're injured in the workplace, it's really important that you understand you've only got 3 years within which to bring the claim from the date that the accident happened. If you don't bring your claim within 3 years, then I'm afraid you're out of time and you can't bring the claim, unless you are able to persuade a judge that there are very valid reasons why you should be allowed to bring it after the 3-year period.
We will assess basically of the firm whether we feel you've got a case or not. So if you was to ring and you briefly explained the accident circumstances to us, we would be able to advise you as to whether we feel it's a case that is something that would be successful.
By obtaining a successful result in an accident at work case, that can give a client a lot of financial peace of mind, not only damages for injury but also for the out-of-pocket expenses that they've incurred as well.